Good morning, Mr. Files. How are you, sir?
I'm doing well, Your Honor. I like the background that you have there.
Well, they kicked me out, man. They kicked me out. I've just set up shop on the corner, literally.
Ah, a drive-in court, literally.
Drive-in court, yes. Drive-in justice is what we call it. All right. Good morning, everyone. I'm going to call this morning's docket. I understand that we may have some attorneys running late, but bailiff, if you will assist me with anyone who is present in the courtroom, I want to ask that you raise your hand, say your name loudly, or just raise your hand when I say here, say present or something so that I can acknowledge you for the docket. And bailiff, if you'll assist me with those in the courtroom. And first we'll begin with Jeremy Ryan Hendricks, CR 281. And Mr. Hendricks is appearing via Zoom in your office, correct, Mr. Fox?
Yes, Your Honor, he is on camera.
Okay, good. All right. We'll come back to him in just a moment after I call this docket, okay?
Thank you, Your Honor.
Judge Martin.
Yes, ma'am.
Erin's not in the courtroom. She's downstairs.
Okay, so if you'll help me. If
Okay, I will.
someone raises their hand or says present or here. CR 15133, George Tracy Jumper.
He's
Thank
here.
you. All right. I see you, Mr. Jumper. Thank you. And Mr. Jumper, Mr. Brian Schmidt had indicated to the court that he may be about 30 minutes late. So don't know if you were aware of that, but he did contact us. CR 19215, Taylor Cravens. Taylor Cravens. Thank you, Mr. Cravens. Is Mr. White there yet, Mr. Cox?
Judge, I believe he's going to be appearing via Zoom today.
Okay.
He's in the courthouse.
Oh, okay.
He's here.
He's here?
I think I'm speaking with the defendant.
Okay. CR 1914, Sean Corey Vance Evans. Is Mr. Evans in the courtroom? Do we know, Ms. Taberham, if Mr. Evans is speaking with Mr. White at all?
I'm not sure. I can go check.
If you don't mind, and let me call the rest of the docket real quick before you leave. CR 19268, State versus Courtney Knapp. Courtney Knapp. Is Courtney present in the courtroom?
No, sir.
We'll need to check with Mr. White on Miss Knapp. And then lastly, CR 16288, Chad Derek Williams. Thank you, Mr. Williams. I see you. All right. Mr. Files, are you ready on Mr. Hendricks' case? I think we were set for a pretrial in that case. Is that correct?
Yes, Your Honor, we have an unopposed, or what's styled an unopposed motion for continuance. Mr. Harrison felt the need to have an expert. We have retained an expert. We have a appointment with him on the 28th. We would anticipate it would take roughly a month for us to have a report back and be ready for announcements.
Or is the expert going to be assisting on like contested pretrial motions, or is this just for trial?
It is primarily for pretrial.
For pretrial? Okay, so you're
for discussion with the prosecutor as far as the resolution of the case.
okay. So Mr. Cox, Mr. Files, Mr. Harrison are requesting additional time on pretrial. Any objection by the state?
No objection from the state, Your Honor.
All right. And you say about a month, Mr. Files?
A month should do it, Your Honor.
All right, we will set Mr. Hendricks then for pretrial again on August 25th. And Mr. Hendricks, this will be the only notice that you get here in open court. Do you understand that?
Yes, Your Honor.
All right, so you're ordered to appear at the 294th. You can appear via Zoom. I have no problems with that, Mr. Files, if Mr. Hendricks wants to appear via Zoom again, since it's—
Thank you. Mr. Harrison is going to be on vacation in Taos, New Mexico on that date. I would assume that I can do the pretrial, but I need to confer with him to see if there's anything that I'm not aware of.
Okay. And that would just, again, pretrial would just be for the announcements of any contested pretrial motions.
Yes, Your Honor.
And then after that, we could set for docket call and move towards resolution.
Yes, Your Honor.
Okay. All right. Then we'll set you, Mr. Hendricks, then on August 25th at 9 a.m. If there's nothing further for you, Mr. Files, then we'll be adjourned in this case.
Thank you, Your Honor.
All right. Thank you, Mr. Files. Good to see you.
And you, Your Honor.
Good morning, Mr. White. How are you, sir?
Your Honor, I'm doing okay. How are you?
Hey, I'm doing fine. A little under the weather, but not too bad. I called a couple of your clients, and I didn't know if maybe you were talking to them outside of the courtroom. Sean, Corey Vance Evans, and Courtney Knapp.
Your Honor, with Mr. Evans, we are trying to, I think we come to an agreement in that matter. Assuming the court goes along with it, there's going to be probably some time as a condition of probation that we've agreed to do on the weekends. We're trying to get our dates on that.
That's fine.
That might take just a minute.
That's fine.
Ms. Knapp is going to also be a plea. Ms. Knapp is coming east of here. I believe she lives a little east of Henderson. She had hit a little traffic and she contacted my office and my office contacted me. That's going to be a plea as well. Mr. Cravens is also going to be a plea, which knocks us down to Mr. Williams. I don't know how many witnesses the state's got. Two.
State has 2 witnesses.
So I will do my best to get these plea papers knocked out. And that way we can get started.
Yes, sir. Sounds like a plan.
Thank you, Your Honor.
Mr. Cox, did I see Mr. Schmidt walk in?
You did, Judge.
Okay. And Mr. Schmidt, are you needing more time to talk with the state, or are you ready on George Tracy Jumper?
Your Honor, Mr. Cox and I have been visiting on this case over the last week. There's one count in the motion to proceed, and I think the state's still evaluating. It's an allegation of a new offense in Henderson County, and the state's still evaluating the case and perhaps attempting to talk with some of the officers involved, et cetera.
That's correct.
And so we're both asking for a reset for about 30 days to see sort of how they want to proceed.
Do we think the Henderson County issue will be resolved in 30 days?
No, Your Honor. Highly unlikely given the backlog there. I don't even expect it to go to grand jury for perhaps 6 months. So I think, I don't want to speak for the state, but I think it was Mr. Cox's intention to either move forward with the count on a preponderance standard here, or, if they don't, obviously just the only other option would be to dismiss the motion since it's the only count. But I think they just want to figure out what they want to do.
That's correct, Judge. I think this case will either be resolved with a dismissal of our motion to revoke, or we'll proceed on our motion and try and prove up the Henderson County offense in a contested motion to revoke.
Okay. All right. Then based on the request by both state and the defense, court will then set this for a contested hearing on the motion to adjudicate on August 27th. If Mr. Jumper can come up to the podium there or come up and sign that notice of appearance, then that way I can see that he's there. And August 27th at 9 a.m.
Your Honor, if he's present in front of the podium, do you see him?
Yes, I do.
With your permission, can you just have a seat and I'll fill all this out and get him to sign it?
Yes, Mr. Jumper, once you sign that notice of appearance, then you'll be free to go.
Okay.
We'll see you back on August 27th.
Judge, once I get all that signed, I'm happy to use. That's all I have this morning.
Yes, sir. Yes, sir. Thank you, Mr. Schmidt.
Good.
All right, Mr. Cox, I'll just stand in recess until Mr. White has wrapped up his plea papers. And then we'll begin Mr. Williams' hearing. And the state has 2 witnesses. Do you know, has Mr. White indicated if he has any witnesses today?
Judge, we are just doing adjudication today, so I do not believe Mr. White has any witnesses.
Okay. All right, thank you, sir. All right, Ms. Grisham, we'll stand in recess and I will send you a message whenever it's time to resume if you want to go back to your office.
Thank you.
You're welcome. All right, are we ready to proceed on Mr. Evans' case, CR 1914?
Yes, sir.
Okay, if we can have Mr. Evans come up to the podium. All right, and we were set today for an open plea, but you're indicating to me, Mr. White, or you indicated earlier that you've reached that Mr. Evans has reached a plea agreement with the state.
That's correct, Your Honor.
And what's that plea going to be?
It's going to be 10 years, probated for 10 years, a $4,000 fine, and 30 days is a condition of probation, which will be served by January the 23rd. As per the probation conditions, he'll serve the last one the weekend of January 23rd. He'll serve 22nd, 23rd, and 24th.
So is he going to do all 30 days on a weekend commit?
Yes, sir.
And you'll have those dates in the judgment?
They're in the probation conditions, Your Honor.
Okay. And what are the court costs in this case?
So $290 and reimbursement fees of $35.
$35 on reimbursement?
Yes, Your Honor.
And the charge is third-degree unlawful possession firearm by a felon?
That's correct.
Yes, sir.
All right, Mr. Evans. Mr. Evans, if you will, raise your right hand for me, sir. I'm going to place you under oath. Do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you put your hand down. All right, Mr. Evans, you are Sean Corey Vance Evans, correct?
Yes, sir.
And Mr. Evans, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yeah. Yes, sir.
Do you feel like you've had sufficient time to review your case with him and have all of your legal questions answered?
Yes, sir.
And you understood everything that you have read and signed in your plea agreement?
Yes, sir.
Mr. White, do you believe Mr. Evans to be competent today?
Yes, sir, I do.
And you've explained to him his legal and constitutional rights?
I have, Your Honor.
Mr. White, I reviewed the pre-sentence investigation report that was prepared in this case. And I had seen that Mr. Evans reported being on certain medications that gave me a question about, mental diagnosis for any kind of mental diseases. It says that he's on tramadol, diazepam, avasartan. Are there any known mental health issues with Mr. Evans?
Your Honor, I have not had any problem whatsoever conversing with Mr. Evans about his case. He knows what's going on. He understands everything he's doing.
Okay. All right. Mr. Evans, you've been charged by indictment with the third-degree felony offense of unlawful possession of firearm by a felon. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years nor more than 10 years confinement in the Texas Department of Criminal Justice. Also carries with it an optional fine not to exceed $10,000. Any judgment handed down by the court or any plea agreement approved by the court must fall within that range of punishment. Do you understand that?
Yes, sir.
And you heard Mr. White state to the court that your plea agreement in this case is that you would be pleading guilty to this offense in exchange for a recommendation from the state that your punishment be assessed at 10 years confinement in TDC, with that 10-year sentence being suspended and you being placed on community supervision for a period of 10 years with a $4,000 fine. And as a condition of your community supervision, you are to serve an additional 30 days in the Van Zandt County Jail on a weekend commit according to your agreement. And then you would have court costs and reimbursement fees. Is that your understanding of the plea agreement, Mr. Evans?
Yes, sir.
All right, thank you. So at this time, Mr. Evans, let me ask you, how do you plead to the third-degree felony offense of unlawful possession of firearm by a felon? Guilty or not guilty?
Guilty, Your Honor.
And Mr. Evans, are you pleading guilty because in fact you are guilty?
Yes, Your Honor.
No one's threatened you, forced you, or pressured you to plead guilty to this charge. Is that right?
That's right, Your Honor.
All right, the court will accept Mr. Evans' plea of guilt at this time. Mr. White, is there any objection to the offer of States 1, stipulation of evidence?
No, sir.
All right, court admits States Exhibit 1, takes judicial notice of Mr. Evans' judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
All right, and Ms. Heisel, are you going to do a summation of the facts?
Mr. Evans was pulled over on I-20 for having a tinted license plate cover that made his license plate unreadable. When the officer approached Mr. Evans' car, he believed he smelled the odor of marijuana. When he asked Mr. Evans if there was anything illegal in the vehicle, Mr. Evans informed him that there was a 9mm handgun in the driver's side door and that he was a convicted felon. Was very cooperative with officers. They placed him under arrest for the unlawful possession of a firearm at that time.
Mr. White, any objection to that summation?
That's correct, Your Honor.
All right. All right, Mr. Evans, then based on the evidence presented to the court will follow the plea agreement in this case. The court finds that there is sufficient evidence to convict you of this offense. The court assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice. Court will find, though, that it would be in the best interest of the community and yourself for that sentence to be suspended and for you to be placed on community supervision for a period of 10 years. Court assesses a $4,000 fine. Court orders you to serve 30 days in the Van Zandt County Jail as a condition of your community supervision. That 30 days can be served on the weekends as provided in the conditions of community supervision. The court orders you to pay court costs of $290 and reimbursement fee of $35. Mr. Evans, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you go with a bailiff to be fingerprinted. And once you're fingerprinted, then you're to report to the probation department and then you'll be free to go.
Thank you, Your Honor.
Thank you, Mr. Evans. Who are you ready on next, Mr. White?
Judge, at this time, we'd ask that we take up the Williams matter. The state has a witness that needs to be back in Dallas by 1:30 this afternoon, so we'd like to take that up now, if that's okay with the court.
Okay, that's fine. All right, and this is CR 18288, State versus Chad Derek Williams. And if Mr. Williams, if you'll come up to council table.
CR 16288, Your Honor.
I'm sorry, CR 16288. And I believe that we're set today on the motion to adjudicate. Is that correct?
That's correct, Your Honor.
All right. And I'm going to give me a second and let me pull up this. And is the state proceeding on the motion to adjudicate that was filed on January 28th of this year?
No, Your Honor, there was an amended motion that was filed February 27th of this year.
All right, give me 1 second. We're going to pull that up.
Yes, sir, that's the one.
All right. All right. All right, it appears that Mr. Chad Derek Williams appeared before the court on February 26, 2019, pled guilty to the offense, the second-degree felony offense of sexual assault of a child. Court heard evidence and found that the evidence substantiated the defendant's guilt. However, court deferred a finding of guilt and placed Mr. Williams on community supervision for a period of 10 years. Court also assessed a $4,000 fine. And I see here that the state has alleged in 4 counts, various ways that they are alleging that the defendant violated the terms and conditions of his community supervision. Mr. White, does your client want the state to read the state's amended motion, or does he waive that?
Your Honor, we've been provided a copy of the amended version of the state's motion to adjudicate. That was not on our portal. However, Mr. Cox did personally email me a copy of that. So we do have a copy of it. As the court's aware, it was filed some time ago. So yes, we do waive reading. Prior to beginning, Your Honor, I have filed a couple of motions on Mr. Williams' behalf. I guess the first thing I'm going to address, Your Honor, is I'm aware of the OCA order that allows for these types of hearings to be done via Zoom with the parties. I'm going to object to the fact finder not being available here. I believe that Mr. Williams' rights to the confrontation of the witness would also include, in due process, also include having a fact finder present to do a proper evaluation of the credibility of the witness. So we're going to object going forward, understanding that the OCA has issued that order.
Okay. Court, having considered that motion and request, hereby denies that request.
Your Honor, we also have filed a motion in the event that the court does find that Mr. Williams has indeed violated his community supervision. We would ask the court order a PSI and proceed to sentencing and hold off its decision as to whether or not to revoke his community supervision until after receiving the PSI and the evidence of punishment witnesses.
State any objection to that request?
Judge, we are going to, at the end of this hearing, we're going to ask the court to adjudicate Mr. Williams and enter a finding of guilt on this cause number CR 16288. Mr. White and I did discuss the fact that he wants a PSI to be conducted. We're not asking the court to assess punishment today. We have no objection to setting a punishment hearing should we get there. We have no objection to setting that out for 2 weeks, 4 weeks, however long it takes the probation department to conduct a PSI. However, again, we are going to be asking at the end of this hearing that the court enter a finding of guilt and adjudicate Mr. Williams guilty.
Okay. All right, Mr. White, I'll take your motion and request under advisement until the end of this hearing.
Thank you, Your Honor. I had filed a motion to quash. I understand that Mr. Gallagher has to be back. If the state doesn't object, and I'm sure they won't since they wanted to take this kind of out of order, that we just take those up after we take up Mr. Gallagher's testimony, and that I'm allowed to make any objections in regard to anything specific as to my motion to quash. I don't know that he would exactly be testifying to my motion to quash, which is count 3. I didn't file anything in regards to count 1, 2, and 4. And I also filed a motion to suppress. I would ask that the court carry that along. I don't think the state's going to object to that either with my written objections. And then carry that along with the hearing.
Mr. Cox.
Well, I do have an objection to both the motion to quash and the motion to suppress. That One, they were untimely filed. We didn't get notice of them. Well, they weren't filed until 4:44 yesterday afternoon. Mr. White and I had a phone conversation late in the afternoon prior to that, around 3:30, where he made me aware he was going to be filing these motions. However, I still feel that they were not timely filed. The other issues with Mr. White's motion we can take up after the testimony with the argument, Judge.
Your Honor, I believe the case law states that, as long as I file a motion to quash prior to commencement of the hearing, that is timely on a motion to revoke or adjudicate, which I did. The motion to suppress is merely a written notice to the state as to what I would be objecting to. I can certainly make my objections during the course of the hearing. If that's preferable to everybody, I'll do that, but it sometimes has a tendency to jam up the hearing.
Okay. So what we'll do is court will take that under consideration. We'll go ahead and we'll take up the testimony of Mr. Gallagher, and then we'll take up the motion to quash and the motion to suppress. So Mr. White, at this time, how does your client enter a plea to the state's motions, to the state's allegations contained in the state's motion to adjudicate?
Your Honor, at this time, counts 1 through 4, Mr. Williams will enter a plea not true.
All right, court will enter Mr. Williams' plea of not true into the record. And Mr. Cox, are you ready for an opening statement, or do you request an opening statement?
I'll waive opening statement, Your Honor.
Okay. All right, Mr. White, do you want an opening statement at this time, or do you want to reserve?
I want to reserve, Your Honor.
All right, you ready to call your witness, Mr. Cox?
We are, Judge. State's first witness is Stephanie Clark.
All right, and if Ms. Clark will come and take the stand, and the bailiff will put you where you need to be.
Mrs. Sadler.
Positions are keeping the same. Can you use that chair? Yes. That's what I see. See if I can see the two folks.
That's good.
You go.
And so, Ms. Clark, as the bailiff has probably instructed you, it's going to be very natural for you to want to look at both the prosecutor and the defense attorney when they're speaking to you. So I'm going to ask you that you utilize this microphone so that when your head's turned away from the computer, I'll still be able to hear you, okay? All right, make sure you speak up loudly and clearly. Go ahead, Mr. Cox. Oh, hang on. Ms. Clark, if you will, raise your right hand. Let me place you under oath. Ms. Clark, do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Go ahead, Mr. Cox.
Thank you, Your Honor. Ms. Clark, would you state your name for the record, please?
Stephanie Clark,
And could you spell that for Ms. Grisham, please?
STEFANIE-CLARK.
Ms. Clark, how are you employed?
I'm employed at Van Zant County Adult Probation Department.
How long have you been with the Adult Probation Department?
10 years.
And what are your job duties with the Probation Department?
To supervise individuals on probation and report back to the court of non-compliance.
Okay, and have you been supervising Chad Derek Williams?
Yes, sir.
Was that in cause number CR 16288?
Yes, sir.
And what was Mr. Williams placed on adult probation for?
Sexual assault of a child.
Do you see him here in the courtroom today?
Yes, sir.
Could you point to him and identify him by an article of clothing he's wearing?
He's got a rust-colored shirt on. Black pants.
Your Honor, we'd ask that the record reflect that the witness is identified and defended in the court.
All right, the record will reflect that this witness has identified the defendant and probationer Chad Derek Williams.
Ms. Clark, when was the defendant placed on probation?
He was placed on probation on, February 26, 2019.
Okay, and when somebody is placed on probation, are the expectations explained then? In other words, are the terms and conditions explained?
Yes, sir.
Who typically explains the terms and conditions to the probation?
The intake officer.
Okay, and that would be done typically here in the courtroom, correct?
No, it's usually done at the office.
Okay. And when the terms and conditions are explained to a probationer, at today's time, the document indicating that they understand those terms and conditions.
They sign a universal intake form
Okay.
that states that they understand what the requirements are.
And Your Honor, at this time, we would ask that the court take judicial notice of the conditions of probation that were filed on February the 26th, 2019. They are part of the court's file, part of the court's record. We would ask that the court take judicial notice of that document and that Mr. Williams sign said document.
Any objections, Mr. White?
Your Honor, we have no objection to the fact that they're in the record, that he signed them. As Mr. Clark did not explain them to him, we will not stipulate that that he understood all the requirements and what they meant.
Okay. All right. Then the court hereby takes judicial notice of the conditions of probation unadjudicated in CR 16-288, filed of record February 26, 2019.
Thank you, Judge. Ms. Clark, I want to go over that document that the court is taking judicial notice of. It's the terms and conditions for Mr. Williams on adult probation, and I don't want to go over all of them because there's quite a few. I just want to go over a few of them. The first one I want to go over is condition B. Do you have that document in front of you?
Condition B?
Yes, ma'am. B as in boy.
Yes.
Could you read for the court what condition B was?
Avoid dangerous or vicious habits, abstain from using alcoholic beverages, abstain from the use of any harmful substances, any synthetic substances, including herbal incense for the purpose of intoxication, narcotic drug, or other controlled substances in any form except as prescribed by a licensed physician for legitimate medical purpose.
And would the use of marijuana be prohibited under condition B of his probation?
Yes.
Next one I want to discuss, Ms. Clark, is on page 3. That's condition T as in Tom. Could you read condition T for the court?
The defendant will submit to and successfully pass polygraph tests during the term of probation at the discretion of the community
You can
supervision
breathe
officer.
when you read. Excuse me, you can breathe when you read.
Oh, I get so used to doing it, sorry.
Sorry.
To determine successful compliance and completion of probation. Initial polygraph fee is to be paid in standard. The final polygraph is to be paid in full 6 months prior to completion of probation.
The next condition, Ms. Clark, is condition Y as in young. That would be on page 4. Could you read that condition to the court?
The defendant is not to patronize any location that sells or deals in pornographic material, nor is he or she to have such items in his or her residence or place of person, or on his place or person.
And condition DD, D as in Daniel. That's a long condition. Basically, that condition says the defendant has to successfully complete sex offender treatment. Is that correct?
Yes.
Your Honor, I'm going to object to that. That's not what it says. It says he has to either be successfully discharged or have to complete the term of probation. There's nothing that says specifically that he cannot be unsuccessfully discharged from.
Give me just one moment. Let me read it here. Condition DD says that he must continue said treatment until successfully discharged by permission of the court, the counselor, or until discharged from probation. All right, so Mr. White, your objection was what again?
Your Honor, this goes to my motion to quash. I wanted to make sure I didn't waive anything. We can take that up at that time. But I set out that I do not believe that this implies, the condition implies that there has to be a successful completion, because they're in the condition itself. It contemplates the fact that he may not be successfully discharged, but in fact may complete probation without being successfully discharged. I think the crux of the condition is that he remain in treatment. Now, this goes in, and I'll clear it up, but he didn't voluntarily refuse to go to treatment, and he didn't violate anything as far as not submitting to the evaluation, not showing up, not allowing certain aspects of the release of information. He was apparently removed. The motion to quash does not state as to why, which is part of our problem, that we weren't given notice on this condition. So subject to that, we believe that his right to confrontation, his rights to, as contained in the United States and Texas Constitution's due process rights, as well as right to effective assistance to counsel and being able to prepare under the Texas Constitution and the United States Constitution to violate it here, because we do not know why he was removed. The state has made no allegation as to why he was removed. Therefore, the actual allegation is contained in the state's count 3 has not been, one, we haven't been given notice. It's not specific enough to bar re-prosecution or a similar motion to revoke over the same alleged behavior, because we don't know what the behavior is. And therefore, the state has not made any showing that he actually did, in fact, violate condition D.
Okay. All right. So I believe that Mr. Cox asked the witness, he summed up that DD required a successful completion of sex offender treatment, and your objection was that that's not what that implies. And the court has taken judicial notice of DD, and DD says until successfully discharged by permission of the court counselor or until discharged from probation. So the court understands the objection, and so we're ready to move forward.
Okay. Your Honor, is the court going to withhold its ruling on that, my objection, until we've heard the motion to quash?
I think so, because I'm not real sure. I thought maybe your objection might be more of a cross-examination question for Ms. Clark, because it does require successful discharge by permission of the court counselor or until discharge from probation. So I think her answer can be both yes and no. So it's hard for
so, yes, sir, I'm sorry. This court, this is awkward. As the court, so the court's taking my objection under advisement and will allow me to question the witness regarding that, because I wasn't expecting. I thought this was going to be something that we take up prior to her testifying.
Yes, yeah, I'll take it under advisement and let you bring that up again with her
without it being under a waiver of any sort of objection. Correct.
Correct.
Okay. Thank you.
Yeah, your objection is noted.
Thank you.
Go ahead, Mr. Cox.
Thank you, Judge. Ms. Clark, the last condition I want to go over is condition GG. G is in Gregory. Could you read that condition to the court, please?
The defendant will not be in possession of any pornography that portrays nudity of a child or an adult in any form. Should the defendant be in possession of any computer equipment or electronic device, no matter what the type, the defendant will agree to the following. 1, the defendant will...
Ms. Clark, you don't need to read that. That's fine. Thank you, though. So these conditions would have been explained to the defendant when he was placed on probation. Is that correct?
Yes.
Okay. Now, in January of this year, you filed a motion to adjudicate and revoke his community supervision. Is that correct?
Yes.
And then in February, you filed an amended version of that motion. Is that also correct?
Yes.
Okay. And by filing that motion, you indicated to the court that you believe the defendant violated 4 conditions of this probation. Is that correct?
Your Honor, wait, can I have witness of order?
What purpose is the board are?
Your Honor, I don't believe the probation office can file a motion to adjudicate. I believe that has to be, I want to make sure the record's clear. I mean, say it has to be she filed it. I don't believe the probation department can file a motion to adjudicate.
I'll rephrase the question.
Thank you.
All right, go ahead.
Mark, you submitted to our office a violation report stating your belief that he violated the terms and conditions of his probation. Is that correct?
Yes.
And then from there, the state files a motion to adjudicate and revoke. Is that correct?
Yes.
Okay. And we'll get into how those conditions were violated with the next witness. But I do want to go back to condition DD. At any point during the pendency of his probation, did the defendant have permission from the court or his counselor to cease sex offender treatment?
He was unsuccessfully discharged at that.
I'm going to object, Your Honor. That's hearsay.
Sustained.
Did he ever have permission from his counselor to cease treatment?
Objection, Your Honor. That's hearsay.
Well, I don't know that it's hearsay at this point, unless she's going to testify that's what someone told her. So I'm going to overrule the objection.
Did he have permission from you to cease treatment?
No.
Okay. I'll pass the witness, Your Honor.
Go, Mr. White.
Thank you, Your Honor. Ms. Clark, just real quick, there was some testimony regarding condition DD. Now that condition contemplates the fact that he may not be successfully discharged from probation during the course of probation, correct?
I didn't understand. I'm sorry.
Okay. He could end probation and still be doing counseling, is that correct?
No.
No?
No.
So if he were to complete probation, it says under condition DD that there are 3 ways for him to stop having to do that, correct? The sex offender treatment.
It says that, yes.
Okay, so one of them is the court could let him off of it.
Yes.
2, the counselor could do that, correct?
Yes.
Or he could be discharged from probation, correct?
If they get close to discharge time on probation and they haven't successfully completed their counseling, I usually extend them.
Okay, well, you have to have permission of the court to extend them, correct?
Yes.
Okay, so in other words, they could theoretically be discharged from probation without a successful completion, correct?
Yes.
Okay, so on this, as long as he remains in treatment during the course of his probation, he has not violated it, correct?
Correct.
Now, you said that you did not give him permission to stop treatment, correct?
No, sir.
So, you're part of the containment team, correct?
Yes, sir.
There are other members of the containment team, correct?
Yes, sir.
Now, if somebody, for example, let's say, didn't pay their probation fees, or not the probation fees, but their fees to the counselor, correct? You understand what I'm saying?
Yeah.
Okay, so let's say they don't pay their fees. They could get discharged from treatment, correct?
Yes.
Okay, now, the actual crux of that would be that they did get unsuccessfully discharged, correct?
Correct.
So, but if they could find another counselor to take them for a fee that they could afford, then they could re-enter probation or re-enter treatment, correct?
Correct.
So, would you agree with me that sometimes during the course of treatment, maybe treatment doesn't progress as some people want it to progress, correct?
Correct.
But the main thing about condition D would be that the person stay in treatment, correct?
Correct.
Y'all want them to be monitored, correct? And the counselor is but a part of the containment team.
Yes.
So what is the containment team?
The would be the probation officer, the polygraph examiner, the counselor, and the court.
So the counselor is just but a cog in this particular containment, right?
Yes, sir.
All right, so if, for example, something breaks or there's a problem, you don't throw the entire, your car, depending on what it is, you wouldn't throw your whole car away, right?
No, sir.
So if somebody's having a problem with the counselor, and I'm assuming that that sometimes happens, it's not unusual for people to go to other parts of treatment, correct?
Correct.
But the main thing is, on this, is that from the time that they, within 10 days, they're supposed to remain in treatment, correct?
Yes.
But simply getting discharged from treatment may not be something that would cause a violation of probation necessarily.
Not necessarily.
Now, let's go to, I'd like to direct you to condition P, about polygraph test. Now, he's got to take the test, correct?
Yes.
And he's also got to pass it, right?
Yes.
Okay, are you aware that the results of polygraph examinations are not admissible in court?
Yes.
Okay, so it kind of becomes difficult for people to prove one way or the other on that as to whether or not he complied with that because the results aren't admissible, right?
Correct.
And I mean, that's just kind of common knowledge. So he doesn't have to take the polygraph examination, does he?
He has to for his conditions of probation.
If he wants to remain on probation, right?
Correct.
And the person, the probationer is supposed to know the conditions of probation, correct?
Correct.
So they feel like that they've also got to pass it, correct?
Correct.
Nobody tells them that it's inadmissible in court, right?
I'm aware.
Did you ever provide Mr. Williams with any documentation saying that he did not have to incriminate himself at any point or in any part of his interviews with you?
No.
Are you aware as to whether or not any such waiver exists in your file?
No.
So there's no waiver exists.
Not that I'm aware of.
Nobody's informed him that he was under no obligation to talk to anyone in regards to any matter if he felt like it might incriminate him.
Not that I'm aware of.
So, with that being said, when we start off on probation and we tell them that they've got to pass the polygraph examination, we're telling them something that while they may have to pass it, that everybody knows that we can't enter it in one way or the other, right?
Correct.
In a way, that's misleading.
I guess it would depend on who you're asking.
Okay, well, the fact is it's right there, it says he has to pass it, but we can't get it into evidence, nobody's supposed to mention them during the course of a proceeding. So when you say, hey, look, you gotta pass this, you understand it, he's not deemed to know the law, is he?
I don't know. I don't know if he knows the law or not.
All right, but nobody ever tells them, hey, look, you don't have to, I mean, you've got to take this, but we can't get it in whether you passed or failed or anything. Right? Nobody tells him that.
No.
Nobody tells him that when he's talking to these people, whether it be the polygraph examiner or whatnot, usually those are people that are either one employed. Well, actually, they're employed by Mr. Williams, aren't they? He has to pay for it.
He pays for it, yes.
And so, he's told that he has to take a polygraph. Does he get choices to who the polygraph examiner is?
He can, if he chooses to, yes.
Is he told that?
I'm not sure if I told him or not.
So he has to pay for it, but he doesn't get to choose it possibly, correct?
Correct.
And so after we get to that point, he's asked to take the polygraph examination. Now, condition T states that he has to, the purpose of this polygraph is to determine successful compliance and completion of probation. Is that correct?
Correct.
Now, in this particular matter, you had requested that a polygraph be administered. Is that right?
Yes.
Now, the allegations say that, and, you know, court's already been made aware. And, you know, at this time, Your Honor, before I go into this, I'm going to ask the court to be able to reserve my objections to what my line of questioning is, since, you know, we've taken things out of order.
So what are you asking me to allow you to
I'm
reserve?
allowing the court, without waiving any sort of error, to allow me to make my objections at a later time as to certain aspects of this, because we're taking the witnesses, you know, the court, I didn't have an opportunity to get rulings on certain matters prior to beginning my questioning.
I guess explain it to me a little bit. You're wanting to ask her questions and get answers
Here's
and then object to them later?
Yes, sir. My position is this. The allegations contained in the state's motion to adjudicate and proceed, or motion to adjudicate and revoke community supervision, contain allegations regarding admissions made during the polygraph, the completion of a polygraph examination. My position is that those statements are not admissible as per they were either one, coerced, made under duress, in violation of his rights to an attorney, his right against self-incrimination, as well as his rights to due process contained under Texas United States Constitution. The rules of evidence provide that we are not supposed to mention polygraph examinations during the course of any proceeding. Therefore, I'm objecting to anything that has to do with any part of the polygraph examination from Dr. Gallagher. That was part of my motion to suppress.
Okay, then the court will allow you to reserve your objections.
Okay. Because I don't want to have to recall Ms. Clark, so I'm fixing to go into some things that would probably be subject to. If the court overruled me, that's fine, but if the court sustained it, I don't want to waive because I asked her any of these questions.
I understand.
Yes, sir. So, he, being Mr. Williams, has to take the polygraphs if you ask him to, correct?
Correct.
And this is determined the completion of probation and successful compliance of probation, correct?
Correct.
Now, the sex offender treatment provider will give you progress reports, is that correct?
Correct.
Now, you don't make any decisions and you don't intervene in his treatment, correct?
No.
Okay, so in other words, when you're asking for a polygraph examination to be administered, you're doing so to determine whether or not he violated the conditions contained within the court's order, correct?
Correct.
Now, if the polygraph examiner, as part of his treatment, wants to polygraph him on a certain matter to determine progress, compliance, etc., within the treatment, which may not be anything to do with probation conditions, he can do so, correct?
I don't understand.
So the polygraph exam, or the sex offender treatment, provider isn't necessarily trying to determine compliance with probation conditions, correct?
No, he's trying to determine whether he's complying with his treatment
Okay.
requirements.
And so some of those treatment requirements may not have anything to do with the listed conditions, correct?
Sometimes.
And in this matter, if the polygraph examination question didn't have anything to do with any listed prohibition by the court, correct?
Okay, I didn't understand that one either, sorry.
Okay, he given a list of conditions, correct?
Yes.
The specific thing that was requested that the polygraph examination was conducted on was not something that was listed within the conditions of probation set forth by the court, correct?
Normally, the polygraphs are under the conditions of probation.
But the question that was requested that he be polygraphed on, that was not a per se violation of his probation, correct?
Which question?
The question that Dr. Gallagher, and the reason why he was referred over to that Dr. Gallagher by you.
He was referred to Jim Gallagher for the polygraph.
That's correct. And you requested that he be polygraphed on a certain matter, correct?
Yes.
And that matter is not a violation of his probation conditions, correct?
He was polygraphed over compliance with his conditions.
He was polygraphed over compliance with, regarding possibly his treatment, correct?
Yes.
Okay, well, you don't intervene in the treatment, sex offender treatment, correct?
No.
So that would be something that the treatment provider would be requesting, correct?
Yes.
So you requested something that didn't have anything to do with any of the conditions specifically that are listed, correct? I mean, like, it's not like you're sitting over there and said, hey, look, we're gonna, I want to polygraph on the issue as to whether or not he had frequented City Park or anything like that, correct?
Correct.
In fact, this particular thing had to do with possibly thoughts that he may have had, correct?
His treatment provider requested the polygraph.
Okay. Well, are you aware that you received a copy of the polygraph, correct?
Yes.
Had you talked to Dr. Gallagher or Jim Gallagher on this?
I had told Jim what we needed to have tested.
Okay, so you requested the polygraph, correct?
Yes.
Okay, and what you requested on, specifically that question, is not in that thought or whatever that you were asked to polygraph.
Judge, I'll stipulate the fact that the question Mr. Gallagher asked in the polygraph was not a condition of his probation.
I haven't seen very young.
I'm sorry, Judge?
I said, say that again, Mr. White. I didn't hear Mr. White's response. I heard the stipulation, but I didn't hear what Mr. White
John,
said.
I don't have anything further from the witness.
Okay, all right. Mr. Cox, any further questions for Ms. Clark?
Briefly, Judge, Ms. Clark, Mr. White asked you about the defendant's understanding of the terms and conditions of his probation, specifically condition DD, you recall that?
Yes.
To your knowledge, did Mr. Williams have an attorney that could explain those conditions to him when he was placed on probation?
Yes.
Judge, we ask that the court take judicial notice of the judgment in this case, which indicates that Mr. Williams was represented by counsel at the time he entered his plea of guilty.
John, I'll go so far as to say that I was the lawyer on that. But the question, what they said, when they were explaining to him, what I explained to him and what they explained to him were two different things.
I understand.
And
So right now it's just the offer, because I think you're going to make an argument. I think the offer is for the court to take judicial notice of the judgment in this case.
Yes, sir.
The court does takes judicial notice of the judgment rendered in CR 16-288.
And Ms. Clark, these conditions, they're imposed essentially by the court, correct?
Yes.
These are the court's conditions.
Yes, sir.
And Mr. Williams, when he entered his plea, agreed to these conditions.
Yes, sir.
Mr. White asked you a bunch of questions about the issue that Mr. Williams was polygraphed on. What was that issue he was polygraphed on?
Mr. Williams.
Subject to my previous objection, Your Honor, I'm going to object to any mention of any sort of polygraph or any sort of admissions that came as a result of the polygraph, as polygraph examinations are inadmissible, as are the results.
Judge, I believe, first of all, I'm not asking for the results of the polygraph examination, but Mr. White relentlessly on cross-examination asked Ms. Clark about that issue that he was polygraphed on. He referred to it as the matter. He mentioned it was over thoughts that the defendant had, and I believe the door has been opened to what that specific issue is.
And I made my objection that, I wanted to be able to do this out, pursuant to my motion to suppress, the court allowed. I just want to make sure that the record is clear that the court gave me leeway in going into that as to pursue it to, but that my objection wasn't going to be that we can't talk about any of this.
And Judge, I'm also not going to be asking the witness what the answer was to that question. I'm just asking the witness what the question was. Because again, the state feels the door's been open to it.
Are we going to cross this bridge with Mr. Gallagher, Dr. Gallagher?
I wasn't planning on it until Mr. White went down this line of questioning about what the question was that was asked of Mr. Williams.
Your Honor, I agree that they could call Mr. Gallagher in somewhat of a manner out of order. And I agree that we could not take up my motion to suppress and my motion to quash until after that was done. Now, I made an objection that I was going to be forced to go into this matter because I didn't know how the court was going to rule. The court said, hey, look, I overrule your motion to suppress. That's fine. The court ruled for it. Then maybe we're not into this matter. But the state is the one who requested that we kind of do this a little bit out of order from how we normally do it. And I made an objection. And now they're saying I opened the door to it.
All right, court's going to sustain the objection to the question.
I'll pass the witness, Judge.
Your Honor, I'll have it confirmed.
Any objection to Ms. Clark being finally excused?
Not from the state, Judge.
No, sir. She can.
All right, Ms. Clark, you're free to go. You can just lay that microphone down there. Thank you. Mr. Cox, any additional witnesses?
State calls Jim Gallagher, Your Honor.
All right, and Mr. Gallagher, if Mr. Gallagher will take a seat in the witness stand, and bailiff, are you there?
Yes, Judge.
All right, if you'll do me a favor, before we use that microphone again, if you'll just wipe that down for Mr. Gallagher.
Yes, sir.
Here's the spray.
Where's Mr. Gallagher? You'll have a signature right here.
Your Honor, can we have just like 3 minutes? I need to walk outside the courtroom for a second.
Yes, go ahead. I'm going to go ahead and swear in Mr. Gallagher, and I'll just have him have a seat, and you can use your 3 minutes. Mr. Gallagher, scoot to your right a little bit more. Can you see and hear me okay, sir?
Yes, sir.
Okay, good. Mr. Gallagher, do you swear that the testimony you give to the court today in this matter, that it will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, please have a seat. And while Mr. White's outside, I'll just give you some tips on testifying in our courtroom there. We are located next to Highway 64, and so sometimes we'll get emergency vehicles or loud trucks that come through. But anytime during your testimony you hear loud truck or sirens or something like that, it would be best if you'll just halt your testimony, let that sound pass, and then continue. And then, of course, at all times, make sure that you allow the attorneys to completely ask their question before you give an answer, and they will, and they should extend you the same courtesy of allowing you to finish your answer before they ask their next question, so that my court reporter can take down a clear transcript of today's hearing.
Yes, sir.
All right, thank you, sir. And then, of course, make sure you use the microphone when you testify today. It helps the court to be able to receive the testimony.
Yes, sir.
All right, thank you, sir. All right, we'll just give Mr. White just a moment. Are you ready, Mr. White?
Yes, sir, I am.
All right, go ahead, Mr. Cox.
Your Honor, at this time, I'm going to object to Mr. Gallagher being called. The polygraph examiner results and the polygraph examination mentioned of it in proceedings are not permissible. I'm going to object to his being called as a witness for any purpose pursuant to also my motion to suppress that the court has taken under or is going to allow us to address at the end of the testimony, as well as subject to my previous objections.
Judge, I have no intention of asking Mr. Gallagher about the results of the polygraph examination.
Is Mr. Gallagher the witness who needs to be back in Dallas by 1:30?
Yes, sir.
All right, so Mr. White, you're objecting to him being called as a witness at all in this matter on the status of him being a polygrapher.
I'm objecting to the fact that he is being called as a polygraph examiner to testify in this matter. Just quite frankly, Your Honor, when a polygraph examiner, since he's subject to, Mr. Williams is subject to having to take polygraph examinations, the assumption could be made adversely as to any of the results on that. I think this is why examiners routinely not allowed to testify under certain circumstances. Certainly, it's well established that the results aren't. I believe that just in general, the calling of an examiner to testify in a matter, particularly as probation, leads to an adverse inference by the fact finder that maybe the results weren't what should have been done or what people wanted, whether they were or not. I believe it's entirely prejudicial. As a result, I believe it violates his rights to a fair hearing because it's clearly a matter that the courts have ruled as to the polygraphs and the mention of even the taking of them as being admissible under any circumstance.
And Mr. Cox, you are telling the court that you're not going to be asking Mr. Gallagher the results of a polygraph.
That's correct, Your Honor.
All right, then the court's going to overrule the objection at this time.
May I proceed, Your Honor?
You may.
Mr. Gallagher, would you state your name for the record, please?
James Gallagher.
How are you currently employed?
I'm the owner operator of BBL Consulting in Rockwall, Texas.
And what do you do there at your BBL Consulting?
Polygraph examinations.
Okay. And would you tell the court a little bit about some of the training you've undergone to be a polygraph examiner?
Yes, sir. I was sent to the Department of Public Safety Law Enforcement Polygraph School by the Dallas Police Department in 1999. Graduated from there, completed an internship back down to Austin for 2 days of testing, obtained my license. In 2001, I was sent to the FBI Academy in Quantico, Virginia, and completed my advanced training in polygraph.
Okay. And Mr. Gallagher, formerly you were in law enforcement, is that correct?
Yes, sir.
Are you currently a law enforcement officer?
No, sir, I'm not. I retired from the Dallas Police Department in 2012.
Okay. And do you sometimes conduct polygraph examinations at the request of different probation departments?
Yes, sir, I do.
And did the Van Zandt County Adult Probation Department request that you perform a polygraph on Chad and Derek Williams?
Yes, sir, they do.
And that
Objection, Your Honor. Again, we're getting into the fact that he conducted a polygraph examination. I want to object that they mentioned or the mention of the polygraph examination is improper, creates an adverse inference, robs Mr. Williams of his right to a fair hearing. Well established that we're not supposed to go into the matters as to whether or not even the examination has been conducted.
I'm going to overrule the objection. And I believe the law is, I could be wrong, but I mean, Mr. Williams is ordered under his conditions of community supervision to submit to polygraph. So I think a mere mention of it, I don't know how a probation probationer would submit to a polygraph and then it not ever be mentioned again during his community supervision revocation hearing. So I'm gonna overrule the objection. Go ahead.
Do you see Mr. Williams here in the courtroom today?
Yes, sir.
Can you point to him and identify him by article of clothing he's wearing?
Yes, sir. He's wearing a red shirt with a white mask.
Judge, we ask the record reflect the witnesses identified the defendant.
Our record will reflect that this witness has identified the defendant and probationer, Chad Derek Williams.
Mr. Gallagher, there are 3 different parts of a polygraph examination, is that correct?
Yes, sir, there are.
Would you explain to the court those 3 different parts of the polygraph examination?
There's the pre-test examination, the actual collection of the charts, and then any post-test interview. The pre-test would involve.
Your Honor, I'm just going to go ahead and object here, ask for a running objection to any line of testimony regarding any of the phases of polygraph examination. I don't know what he's going to testify to just yet, but obviously any testing phase or post-test could, it is also my contention that even the pre-testing phase mention of it violates Mr. Williams' rights to a fair hearing. I'd ask for a running objection to the entire line of questioning.
All right, I'm going to overrule your objection, but I will grant your running objection going forward.
Thank you, Doctor.
Mr. Gallagher, could you explain to the court what the pre-test interview is and what the purpose of that is?
Pre-test interview is a collection of biographical information, explanation of the polygraph process, purpose of the examination, and would involve probation department's review of terms and conditions of probation, and then construction of the questions and preparation for the actual examination.
And then there's the actual polygraph examination itself, correct?
Yes, sir, collection of the charts.
Okay, and we're going to pretty much skip over that whole part of the process, and I want to move to the post-test interview. Would you explain to the court what the post-test interview is and what the purposes of that is?
If the charts are deemed deceptive in the state of Texas, you have to give the subject an opportunity to explain his deceptive responses, and that's what's done in the post-test. The examinee is advised of the results of the examination, give an opportunity to explain why those results are deceptive.
Okay, and Mr. Gallagher, you testified earlier you're not a law enforcement officer, correct?
No, sir.
And when you perform a polygraph, the person you're performing it on, do they sign a sort of a waiver?
Yes, sir, they do.
And what's contained in that waiver?
It's there's several paragraphs. Do you want me to review the entire waiver, sir?
No, Mr. Gallagher, if you could just go over some of the things that the subject agrees to when they consent to a polygraph.
The first paragraph of the waiver, it explains the pre-test that I just went through. It then tells you about the second part of the examination, the chart collection. Then the third part, which would be the post-test. There's also a paragraph in here that, having been fully advised of all of the above with full knowledge and understanding thereof, I hereby voluntarily and agree to consent to the examination. My attorneys put in an extra paragraph in there about hold and harmless as far as my LLC. He states that age designates who will get the results of the examination and signs it and dates it on the back. There's some general health questions. Just ascertain this fitness to take the examination.
And did Mr. Williams sign that consent form?
Yes, sir.
And what was the date you performed this polygraph examination?
December 18, 2009.
So you did not force Mr. Williams to participate in this polygraph, is that correct?
No, sir.
There was no coercion or duress or anything like that?
No, sir, not allowed in the state of Texas.
Okay, you didn't pick him up in a police car and drive him there and make him do it?
No, sir.
So, Mr. Gallagher, I want to go to the pre-test interview. At any point in the pre-test interview, did Mr. Williams make an admission to you regarding the use of marijuana?
I want to object, Your Honor, that's hearsay.
Your Honor, is the admission of party opponent and statement against interest?
Your Honor, he's not part of the state of Texas. He's not a party to this. He doesn't work for the state of Texas. He's not a current law enforcement officer. So the party opponent exception does not apply here.
Party opponent is Mr. Williams, Your Honor.
Yeah, that's my understanding as well. I'm going to overrule the objection.
Mr. Gallagher, did Mr. Williams make any admissions to you about the use of marijuana?
Yes, sir, he did.
Did he say why he used marijuana?
He said that he smoked marijuana the night before the examination with a friend and it relaxed.
And the night before would have been December 17th, 2019, is that correct?
Yes, sir.
Okay. If I could have 1 minute, Your Honor, I'm sorry. Did Mr. Williams make any other admissions to you regarding the terms and conditions of his probation in the pre-test interview?
Yes, sir, he did.
What would that be?
In relation to viewing pornography.
What did he say about pornography?
Your Honor, I'm going to object again to being hearsay.
Overruled. You may answer, Mr. Gallagher.
Yes, sir. He said prior to November 2019, he had masturbated to thoughts of not only his victim, but to...
I'm going to object, Your Honor. That is not what the question was. He was asking about pornography. The question is non-responsive to it. I'm going to object to the witness being non-responsive to the question and to going into matters that aren't part of the probation conditions.
Response, Mr. Cox.
Judge, I'll narrow the question.
All right, sustain. I'm going to sustain the objection.
Ask the court to disregard it.
All right, court will disregard.
Mr. Gallagher, did he make any admissions to you regarding pornography?
Stated he viewed adult pornography in January 2019 after being placed on probation, and again in June of 2019. He has an old pornographic DVD that he watched on these occasions. On 2 occasions, he went to a pornographic drive-in movie, an adult bookstore in Tyler, Texas, and viewed pornographic movies.
So he admitted to you that he viewed pornography in June 2019, is that correct?
Yes, sir.
Okay. And he also admitted to owning a pornographic DVD, is that correct?
Yes, sir.
Okay. And on 2 occasions, he went to a pornographic drive-in theater in Tyler, is that correct?
Yes, sir.
And viewed pornography there?
Yes, sir.
And did he admit to you that he did that while he was on probation?
Yes, sir.
Okay. I'll pass the witness, Your Honor.
Mr. White.
Yes, sir. Mr. Gallagher, you stated that you're a former law enforcement officer, is that correct?
Yes, sir.
Are you familiar with the line of cases that has to do with having someone like question them, then Mirandizing them after they get to talking, and then trying to get the rest of the statement in and have them start over? You remember that phenomenon?
If you're referring to custodial as opposed to non-custodial interviews or interrogations, just that, and I understand that started after I left. In our cases, we felt when we brought somebody in there, a witness, it not Mirandized. When I was there in homicide, we felt they were a suspect, they were Mirandized immediately, but I had heard of that since.
That idea being that if you get somebody talking, they're more likely to keep talking, right?
After the Mirandized?
Before the Mirandize, if you get them talking, then you Mirandize, and they're more likely to talk after the Mirandize, right?
I've only done that in cases where they have began to incriminate themselves during the initial.
And I'm not saying you did it, but you're aware that
Yes, sir.
there was a lot of cases where the Supreme Court said
Yes,
we
sir.
can't do this. Because, you know, once people kind of get to talking, they tend to kind of keep talking, right?
Yes, sir.
That's always what's important about getting people to talk, right? That's what's important about getting people to initially start talking, right?
Another way to say that is tell the truth. Yes, sir.
Well, I mean, you like them to talk, get to talking first, right?
Yes, sir.
Okay. So, with that being the case, did anybody ever advise, did you, not anybody, if you don't know, did you ever advise Mr. Williams that if he said anything that could incriminate him, that it might be used at a later time against him?
Let me double check the waiver here. In the waiver that he signed, I understand the final.
I would object to the witness reading out off something that's not evident.
Let's sustain the objection.
Yes, sir, to answer your question.
Okay. So, in this type of situation, let's say that somebody is put into a position to where they have to have a result. Or you're aware that your testimony as to the results on this are generally not permissible on in any prosecution, correct?
No, sir, it was an understanding, it said whatever information, whatever we.
I didn't ask you that, I asked you, what I asked was, do you understand that your testimony about the results of polygraph examination are not admissible, correct?
No, sir, I have a good understanding that I've testified in court that it before the state test.
Okay. So, were you in a situation here where were you aware that he was told that he had successfully passed this?
Objection, speculation.
Ask your question again, Mr. White.
I asked him if, Your Honor, I asked him if he was aware that he was told that he had successfully passed this.
I'm going to sustain the objection unless Mr. Gallagher does have personal knowledge.
I do not have personal knowledge of that.
In other words, you didn't know, you're not familiar with his conditions of probation, correct?
I wouldn't be familiar with what the probation officer told him about the Texans.
And so you're not familiar with Mr. Williams' conditions, correct?
I'm familiar with his conditions as far as what Manzana County requires of its probationers that are on probation with this particular type of operation. Yes, sir.
Yeah, but you didn't go over his conditions personally.
No, sir.
So, when someone comes in and takes a polygraph examination, they're generally in there for a reason, right? It's just not, you know, when they're sent by a probation officer, correct?
I didn't understand.
They're in there for a specific reason when they come in there and take a polygraph examination, correct?
Specific to terms and conditions of probation and particular concerns by the probation officer. Yes, sir.
Okay, and you understand that submitting to that polygraph is a requirement of his probation, correct?
Yes, sir.
Now, obviously, he agreed to go on probation, correct? Because he's in there.
I have second knowledge of that. Yes, sir. He was there, so that would be an assumption, but yes, sir.
And you knew that he was in probation, right?
Yes, sir.
So, you know, when he gets in there and you start having to do this, there is some inequity in this, correct? In that you're the examiner and he's the probationer, right?
Inequity?
Yeah. In terms of y'all are not on equal footing, right? He's hiring you to do a job, right?
Yes, sir.
Okay. And you're reporting back to the probation department, correct?
Yes, sir.
Did you ever inform Mr. Williams that he didn't have to use you as the examiner?
He said, we didn't speak to that directly. No, sir.
So he's sent up there, he's taken a polygraph that he's required to take. In that particular type of situation, like I said, he's being kind of ordered to do something, right?
My understanding is yes, it's part of terms and conditions of probation.
And your understanding is he didn't come in there voluntarily from the standpoint of, I just want to go take a polygraph with Mr. Gallagher. He was told to come back.
It's voluntary in the state of Texas. His reasons for his voluntariness are his own. But why he walks through that door is up to him. And if he sits down in that room and says, I'm not taking the test.
I understand that. But you also recognize, that the bargaining power there is not exactly the same, correct?
I agree.
And you're unaware as to whether or not he was told, not by you, but by the probation department, you'd be unaware as to whether or not he was told about any of his rights in regarding to who he chooses as the examiner or what his rights were in regards to how he dealt with the
Objection again to speculation, Your Honor.
I'm going to sustain the objection.
Your Honor, I'll rephrase it. Outside of what you know you told him, okay, you're not aware of if he was given any other alternatives, correct?
I was aware there was a previous examination.
Objection, Your Honor. I asked him if he was aware when he went to Dr. Gallagher as to whether or not he'd been given any other options when he went to Dr. Gallagher. I mean, Mr. Gallagher. Non-responsive.
Okay, I'll sustain the objection to non-responsive. Can you answer that specific question, Mr. Gallagher?
And you're not aware as to whether anybody else within probation department informed him of any rights he would have in regards to not talking to you, correct?
Correct.
That's the witness, Your Honor.
No more questions, Judge.
All right, any objection to Mr. Gallagher being finally excused from the hearing?
State, Your Honor.
No, sir.
All right, you're free to go, Mr. Gallagher. Thank you, sir. Mr. Cox, any additional witnesses?
No, Your Honor. At this time, the state would rest in the adjudication phase.
All right. And Mr. White, are you calling any witnesses today?
I am not calling any witnesses today, Your Honor.
Okay. All right. So let's do this then. Let's I know Ms. Grisham won't be happy with me, but let's take a break in this case and let's go ahead and entertain your other two pleas. And then we may bring Mr. Williams back after lunch to finish discussing the motion to quash and motion to suppress. So Mr. Williams, you're free to go until 1:30. All right, Mr. Williams, you're free to go until 1:30. Be back at that time. All right, Mr. White, who would you like first?
Let's do Mr. Cravens because he's going on probation.
Okay. All right, court call CR 19-215, State versus Taylor, Ethan Cravens. Mr. Cravens, if you'll make your way to the podium, please, sir. And Mr. Cox or Ms. Heisel, can someone tell me the terms of the plea agreement?
Your Honor, we're reducing, indicted as a aggravated assault, we're reducing it to a Class A misdemeanor assault causing bodily injury. Mr. Cravens is going to be placed on probation for a period of 2 years. We're asking the court to defer finding of guilt. Mr. Cravens will be responsible for $26,784 in restitution. This to be paid out to different medical providers. There is a restitution sheet that lays out where those payments are to go.
Is there a fine?
No, there is no fine, Your Honor, because of the amount of restitution. There's no fine. $270 in court costs and a $35 reimbursement fee. Additionally, Your Honor, there is a victim impact statement which the court is supposed to review before accepting a plea, and it just dawned on me that we have not provided the court a copy of that victim impact statement. I would be okay with the court reviewing it after the plea, if that's okay with the court.
Is the victim in agreement with the plea bargain?
He was concerned about his medical bills being reimbursed, but he is in agreement with the plea. Yes, sir.
And
Okay.
I got you.
All right.
Judge, as I stated earlier, the medical expenses are going to be paid to primarily medical providers in different hospitals. There was a very small out-of-pocket payment incurred by the victim. However, I believe Mr. White has agreed that payment will go first to the victim before going to medical providers.
Okay. All right. Then the court will take up the victim impact statement after the plea on the basis of the state's statement that the victim is in agreement with the plea agreement they've reached with Mr. Cravens. All right, Mr. Cravens. Mr. Cravens, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. You are Taylor Ethan Cravens, correct? Are you a United States citizen?
I am.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
I have.
You have or have?
I have. Yes, sir.
Okay, and what have you been diagnosed with?
PTSD.
And are you currently on any type of medication for PTSD?
No medication, no, sir.
Do you feel like you not being on medication in any way inhibits your ability to understand the proceedings that have been brought against you?
No, sir.
Okay. Mr. Nolan White is your attorney. Are you pleased with his representation of you?
I am.
Feel like you've had sufficient time to go over your case with him, have all of your legal questions answered,
Yes, sir.
and you've understood everything that you've read and signed?
I have.
Mr. White, you believe Mr. Cravens to be competent today?
Yes, sir, I do. And to speak very quickly to allay any concerns that the court might have, I've represented Mr. Cravens for some time. Mr. Cravens has also done some inpatient counseling as well. And I've made the state very early on aware that he suffers from post-traumatic stress disorder. He's a veteran. He's been in contact with the VA. You know, Mr. Cravens has done a lot to try to help himself in that regard. And so I don't have any problem at all. I mean, I've never had any problem communicating with him. And I'm quite certain that he understands what he's doing.
All right. Thank you, Mr. White. All right, Mr. Cravens, you have been indicted by the grand jury with the second-degree felony offense of aggravated assault causes serious bodily injury. However, it appears that the state is recommending a plea agreement wherein the charge would be reduced to that of a Class A misdemeanor assault causes bodily injury. the range of punishment for a Class A misdemeanor is confinement up to 365 days in the Van Zandt County Jail and a fine not to exceed $4,000. Any sentence handed down by this court or plea agreement reached by you and the state would have to fall within that range of punishment. Do you understand that? All right. And you heard the statement earlier that the plea agreement is that you're going to plead guilty to the Class A misdemeanor offense of assault causes bodily injury. And the state's going to recommend that the court review the evidence, but defer a finding of guilt in your case. And that means that you would not be convicted of the offense. And you would then be placed on community supervision for a period of 2 years. And then you would be responsible for restitution in the amount of $26,784. Is that the correct amount, Mr. Cox?
It is, Your Honor.
Okay. And you would have a 0 fine, $270 court costs, and $35 reimbursement fees. Mr. Craven, is that your understanding of the plea agreement?
It is.
Mr. Cravens, how do you plead to the Class A misdemeanor offense of assault causes bodily injury? Guilty or not guilty?
Guilty.
And Mr. Cravens, are you pleading guilty because you're guilty of that offense and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this offense?
No, sir.
All right, the court will accept Mr. Craven's plea of guilt. Mr. White, any objection to States 1?
No, sir.
States 1 is admitted into evidence, and the court has taken judicial notice of Mr. Craven's judicial confession. Is there anything further from the state?
No, Judge, rest in close.
Other than the victim impact statement, I'm aware. Anything further from the defense?
Your Honor, we have nothing further, and we don't object to the state introducing that to the court after proceeding.
All right. And who's going to do the summation of facts for me?
I will, Your Honor. It's fairly simple. It was a bar fight at a Grand View Roadhouse in Wills Point. The defendant, along with a co-defendant who's now deceased, assaulted the victim. I think the brunt of the injuries occurred when the victim was trying to sign his credit card bill at the bar and was sucker punched. He suffered numerous broken bones in his face.
Okay. Thank you, Mr. Cox. Mr. White, any objection to that summation?
No, sir.
All right. All right. Then based on the evidence before the court and the recommendation of the state, the court will follow the plea agreement in this case. Court hereby finds that there is sufficient evidence to convict Mr. Cravens of this offense. However, the court defers a finding of guilt, places Mr. Cravens on 2 years community supervision. Court orders him to pay restitution to the individuals or organizations indicated on the judgment in the amount of $26,784. Court assesses $270 court costs and a $35 reimbursement fee. Mr. Cravens, you've gone over your conditions of community supervision, have you not?
Yes, sir.
And you understand what's required of you.
I do.
And you understand that if you violate your terms of community supervision, that you could be brought back before the court. And if proven, then the state could request the court to sentence you up to 1 year in the Van Zandt County Jail.
Yes, sir.
All right.
I'm sorry. Your Honor, plea paperwork has not been sworn to yet. Perhaps the court could swear Mr. Cravens to the plea papers.
Okay. All right. Mr. Cravens, the plea papers that you have completed with your attorney, Mr. White, today bears your signature, does it not?
Yes, sir.
And you would tell me that everywhere that you've signed that because you have stated that that is your true signature and you understand everything that you're signing in court today.
Yes, sir.
Okay. All right. Mr. Cravens, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out terms and conditions of the sentence. I'm going to have you go with my bailiff to be fingerprinted, and then you're to report to the probation officer.
Yes, sir.
All right, Ms. Knapp. All right, court call CR 19268, State versus Courtney Knapp. Ms. Knapp, if you will, raise your right hand for me. I'm going to place you under oath, ma'am. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You may put your hand down. And Mr. White or Ms. Heisel, can someone tell me the terms of the plea agreement today?
Yes, Your Honor, this now is going to plead to the lesser included offense, driving while intoxicated, first offense, class B misdemeanor. The state is going to recommend punishment is that's a 3 day in Van County Jail, credit given for time.
Hey, Ms. Heisel, I'm sorry. I'm having a hard time hearing you. Can you just come closer to the,
Judge, does you remove the mask off?
okay. So it's a DWI 1, right?
Yes, DWI first class B.
B, okay, that's what I thought. I just want to make sure. And it was 3 days in jail?
3 days in jail, and credit for time served. A fine of $2,000. And the state is also going to agree to 1245 for filed misdemeanor M 1800797, which is a violation of occupational driving license charge. With a $2,000 fine, $270 in court costs, and $35 in reimbursement.
All right, let me repeat that back so I can make sure that I got that all down. All right, so original charge was state jail felony DWI with child passenger, reduced to class B DWI, 3 days in jail with credit for 3 days, $2,000 fine, $270 court cost, $35 reimbursement fee, and $1245. And this, I may not have heard this correctly, unfiled M 1800797.
Correct.
Is that correct?
Yes.
Okay. All right. All right, Ms. Knapp, are you a United States citizen?
I am.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Depression, anxiety, and PTSD.
Are you currently on medication for any of those?
Yes, sir.
And what medications are you on?
Wellbutrin, clonazepam, Prestige, Topamax, I think that's all. I'm sorry.
Okay, that's okay. Do you feel like those medications help you and assist you to understand the proceedings that are going on today?
Yes, sir.
You feel like you've had clarity of mind and thought, and that you do understand everything that's occurred in your case?
Yes, sir.
Okay. And your attorney is Mr. Nolan White. Are you pleased with his representation of you?
Very much so. Yes, sir.
And do you feel like you've had sufficient time to talk with him about your case, have all of your legal questions answered?
Yes, sir.
Mr. White, you believe Ms. Knapp to be competent today?
I do believe she's competent, Your Honor.
All right, and you've explained to her legal and constitutional rights?
I have, Your Honor. I believe that she understands those rights. I believe that she's waived those rights knowingly, intelligently, and voluntarily.
Thank you, Mr. White. All right, Ms. Knapp, the plea agreement that you have reached with the state is for your charge to be reduced from that of a state jail felony to that of a Class B misdemeanor. A Class B misdemeanor offense of driving while intoxicated in the state of Texas has a range of punishment of confinement in the Van Zandt County Jail up to 180 days and a fine not to exceed $2,000. That means any sentence handed down by this court or plea agreement that you reach must fit within that range. And it's my understanding that the plea agreement in this case is that you would be pleading guilty to the DWI Class B misdemeanor offense, and the state would recommend 3 days confinement in the county jail. You would be given credit for 3 days, and you would have a $2,000 fine. That to the court, that appears to fit within that range of punishment. Is that your understanding as well?
Yes, sir.
Okay, so then let me ask you, Ms. Knapp, to the offense of driving while intoxicated, a Class B misdemeanor that occurred on November 27th, 2018, how do you plead? Guilty or not guilty?
Guilty.
And Ms. Knapp, are you pleading guilty because you are guilty of that offense?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept Ms. Knapp's plea of guilt. Mr. White, any objection to State's one?
No, sir.
State's one's admitted into evidence. The court has taken judicial notice of Ms. Knapp's judicial confession. Is there anything further from the state? Anything further from the defense?
No, sir.
All right, and Ms. Heisel,
Yes, Your Honor. Summation back. Judge, are you ready for me to proceed?
yes, I'm ready.
Your Honor, Ms. Knapp was traveling through Wills Point on US Highway 80 when 911 caller notified Wills Point police that there was a reckless driver. Wills Point officer got behind Ms. Knapp, noticed she was failing to maintain a single lane, and executed a traffic stop. Knapp was very lethargic, slow to answer questions, drowsy. She stated that she was tired. The officer believed that there were signs of intoxication, so he called out a state trooper to conduct field sobriety tests. That state trooper, after witnessing multiple signs of intoxication during those tests, did decide to place her under arrest for driving while intoxicated. There was her 3-year-old son was in the back seat. And the trooper then applied for there was blood draw given, not by warrant, by Ms. Knapp's consent, and that blood draw did detect multiple narcotics, medications, but the only one that registered a detectable amount was clonazepam, and she had 0.04 milligrams per liter of clonazepam in her system at the time of the blood draw.
All right, thank you, Ms. Heisel. All right, the court, having received the evidence, finds that there is sufficient evidence to convict Ms. Knapp of this offense. The court will follow the plea agreement as recommended by the state. The court hereby convicts Ms. Knapp of driving while intoxicated, Class B misdemeanor offense. Court assesses punishment at 3 days confinement in the county jail. Court will give Ms. Knapp credit for the 3 days time that she has already served on this case. Court assesses a $2,000 fine, $277 court costs, and $35 reimbursement fee. Court dismisses under section 1245 unfiled DA number M1800797. Ms. Knapp, you need to, before you, I don't know if the court compliance officer, it's lunchtime, so she may not be there, but after you leave the court today, bailiff, if you're in there, I would just ask that you give Ms. Knapp a copy of Ms. LaPrat's card so that she can be in contact with her, so that Ms. Knapp, I'm going to order you to contact the court compliance officer so you can make arrangements to pay your fine and court costs and reimbursement fees. Okay. Failure to pay your fine, court costs, and reimbursement fees will result in a warrant being issued for your arrest. Okay. You understand? All right. So Ms. Knapp, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you go and be fingerprinted with the bailiff, and then you'll be free to go.
You just be the favorites.
All right, we'll stand in recess until 1:30.
We come back here.
Yes, sir. Well,
Okay, thank you.
well, if you all would rather do it in your office, that's fine. If we're not gonna be taking up any more testimony.
I just come back here.
Back here? Okay, that's fine. Okay, yeah, okay, I'll see you at 1:30 then.
Yeah.